any unintended injustices. I commend the bill to the House.
Dennis O'Rourke.
Thank you, Mr Speaker. This bill effectively reenacts the Prisoners and Victims Claims Act 2005 so that it will continue in force beyond the extended sunset date of 1st of July 2013. So the restrictions in the current law and the process by which prisoners' victims can claim for an award made to a prisoner are simply carried over indefinitely. Mr Speaker, New Zealand First expected a new, updated piece of legislation rather than a simple reenactment of the 2005 law. So this bill in this form is something of a surprise to us. And I would have to say, having just listened to the last speaker, that is a review looked at through rose-coloured glasses, and it's not something that New Zealand First will do. We expect a rigorous examination of the current regime under the current legislation to see, firstly, whether it does in fact work, and secondly, whether it achieves its stated objectives. New Zealand First will vote for the bill, but only as far as the Select Committee, which we wish to carry out a thorough examination of it. We expect changes, and we expect a genuine review as part of the committee process. And as far as we are concerned, that will mean a full examination of the original 2005 legislation, not just an examination of the provisions of this particular amendment bill. Now, Mr Speaker, I'm not saying, and New Zealand First is not saying necessarily, that the current legislation is a failure. I do not know, we do not know yet whether that is the case. But we do know that the principles must include these things. First of all, being a prisoner means being penalised only by the temporary removal of personal liberty and by incarceration. It doesn't mean any additional punishment in any way concerning prisoners' claims. Prisoners should have the opportunity for rehabilitation, education and reorientation in their direction of their future life. And secondly, it does not mean that there should be any loss of other rights for prisoners. It does not mean the loss of right to accident compensation for genuine injury or disability from genuine accidents. It does not mean the loss of right to compensation for significant mistreatment should that occur. On the other hand, the rights protected in this way must be balanced against the fact that there is considerable concern in the community that prisoners abuse some of those rights, and we all know that there are cases where that has happened. Those are genuinely held concerns, however, in the community, and we must give full attention to them. And we certainly should not mollycoddle prisoners and should make sure that there are no rorts of the kind that we have seen by some prisoners in the past. New Zealand First will want to make sure that the reenacted legislation is appropriate in restricting claims by prisoners, because there is a case for that. On the other hand, prisoners can also be victims and their rights must also be appropriately protected. So that is where the balance must be struck. Achieving the balance that protects the rights on the one hand of prisoners and on the other meeting community expectations that prisoners' compensation be accessible by their victims to meet the properly awarded claims made to those victims. The Select Committee will be the place for all that to be looked at. One of the matters I think that needs consideration is section 13, which says in subsection 1 that no court or tribunal may, in these sorts of proceedings, award any compensation unless it is satisfied, firstly, that the plaintiff has made reasonable use of all the specified internal and external complaints mechanisms reasonably available, but has not obtained in relation to that redress that the court or tribunal considers effective, and in B, another remedy or combination of other remedies cannot provide redress that the court or tribunal considers effective. Now, the possible problem with that legislation is in the words redress that the court or tribunal considers effective. I think that needs further consideration, and it certainly needs advice from officials as to how that sort of assessment has actually worked in practice. And in Clause 2 of Section 13, there is a need for similar reconsideration and advice, because that refers to, and I quote in this section, reasonable use of a complaints mechanism means the use the court or tribunal considers it reasonable for the plaintiff to have made in the circumstances. So reasonable means reasonable. And that's a brilliant thing to say in a piece of legislation. So what does it mean? We're going to have to get some advice on that and to see what effect that it's had in practice. It's a subjective test, and we all know that is often the cause of considerable trouble in other legislation. And in Section 14, there are other matters to be reconsidered too, because that says that a court or tribunal must take into account certain matters which are specified in subsection 2. And those include these. In B, the quantum of an award to provide effective redress. Now, what is effective redress? Effective compared to what? I'd like to hear about that from the officials. And we also see, for example, in subsection 2B, whether the defendant's breach of or interference with the right concerned was deliberate or in bad faith. That's something to be taken into account. I don't understand really why that's relevant, given that it's the breach itself which is the issue, not whether it was deliberate or bad faith. But I'm willing to listen to explanations about that too. And in 2C, the words relevant conduct of the plaintiff are used. Relevant to what? What does that mean? There's just not enough guidance, and I'd like to hear advice about that as well. In 2G, we see the provision, the extent, if any, to which effective redress in relation to that act or omission has been or could be provided otherwise than by compensation. I'd like to know whether that actually occurs in practice, and if so, how well it's worked. And finally, in H, any other matters the court or tribunal considers relevant. That's a pretty open-ended invitation, and I'd like to hear more advice on that too. However, Mr. Speaker, I want to make this clear in closing. Firstly, New Zealand First does want to see an effective and practical way of facilitating victims' claims against prisoners, because we in New Zealand First do believe in promoting victims' rights, and this is one valid way of doing it, provided prisoners' rights are also appropriately protected. But it must be workable and it must be fair. And as I've already said, important prisoners' rights must not be unduly compromised. I think there is a lot in the 2005 piece of legislation that needs review, needs clarification and needs improvement. So as I've said, it's a surprise that this is simply being put up for reenactment without that review and without that improvement. So that's something we'll simply have to try and do through the committee process. Nevertheless, I look forward to the committee stage to discuss all of that, and for that purpose, Mr. Speaker, New Zealand First will support the bill to the committee stage, but we may well not consider it further unless the government is willing to consider improvements and amendments to the bill.
Dr. Jackie Blue.
Mr. Speaker,